It's a surprise, but one of the hottest issues in this debate over the Trans-Pacific Partnership is a provision called Investor-State Dispute Settlement. And a year ago, nobody knew about that. The acronym is ISDS, Investor-State Dispute Settlement. And this has been a provision in about 2,200 bilateral investment treaties since 1959, and it's been a provision in all of U.S. free trade agreements since NAFTA. But suddenly it's very controversial. The reason it's controversial is that opponents of the Trans-Pacific Partnership see it as a giveaway to big corporations, multinational corporations. And they argue that it's unfair for these multinational corporations to have a special arbitration mechanism to deal with their grievances against countries abroad where they do business. That's the basic argument. So let me say just a little bit about what these ISDS provisions are, Investor-State Dispute Settlement, and some of the what I would call misinformation, even disinformation about them. The Investor-State Dispute Settlement provisions say that a country should not expropriate the property of a foreign investor without paying compensation. And it shouldn't expropriate it except for a public purpose. In other words, you're not supposed to take away property and give it to a private owner. Secondly, they say that investors, foreign investors who come to a country should get the same treatment as local firms investing in that country. That's called national treatment. And third, there's kind of a catch-all provision saying that governments should give foreign investors fair and equitable treatment. That language has been used, as I said, thousands of times. Well, the opponents of the Trans-Pacific Partnership and the ISDS mechanism put out hypothetical examples suggesting that the ISDS provisions will be used in an arbitration case against, for example, let's say the state of California, arguing that some regulatory provision by the state of California, an environmental provision, let's say, or a health provision, reduces the value of the investor's property, the foreign investor, let's say a Japanese firm or an Australian firm, and therefore the U.S. government should compensate that investor to the tune of several hundred millions of dollars or even billions of dollars. That's the basic hypothetical, which I regard as far-fetched, but you can't say it's impossible. There have been 13 cases under ISDS brought against the United States by foreign investors doing business here. No foreign investor has won a case against the United States because when you look at the whole body of ISDS provisions, actually they pretty closely mirror U.S. law in the Fifth Amendment to the Constitution and other provisions in U.S. law about not expropriating property except for public use and so forth and so on. But the hypotheticals are there. And the other thing that opponents of the Trans-Pacific Partnership argue about ISDS, there's one provision of this vast agreement, is that it's a special court kind of, it's an arbitration proceeding for corporations. And, why should corporations get special treatment? And they make quite a bit of that particular argument. But the fact of the matter is that if the Trans-Pacific Partnership is ratified, there will be labor provisions in it which have not been tested in any arbitration proceeding so far. And if you read the language of the labor provisions, these are the International Labor Organization fundamental principles and rights at work. They are very broad against discrimination, against child labor, against other bad practices in the labor. So it's not that only corporations have recourse under the TPP for inappropriate government behavior, but also there will be provisions on labor and also on environmental. If there are environmental abuses, those will also be subject to TPP. So I think the special provision for just the benefit of multinational corporations, I think that's misleading as to what exactly is happening. Now, are there fair criticisms of ISDS? I would say yes, and many scholars who have looked at this say yes. It's a very active issue right now. And so I would single out maybe three aspects of the ISDS chapters, the way they've worked, and there have been several hundred cases that have been decided, and you could complain about the outcome of any one of those cases, I guess. One aspect which I think is wrong is that in the arbitration proceedings, the briefs don't have to be published. They can be secret. They can be kept secret. Nor does the decision have to be published unless the parties agree. Now, sometimes parties like this, that is both the government and the investor, they want to keep things quiet. Maybe they want a settlement in the meantime, and they don't want all this controversy out in the news media. But there is a public interest in how these decisions are reached and what the rationale is, and I think the pleadings and the decisions should all be public, which is true in the World Trade Organization when they decide trade disputes. It's obviously true in U.S. courts when they decide disputes. So that's one, I think, fair criticism. Another fair criticism is that the mechanism of all these arbitrations, as I said, there have been about 500 over the last, 50 years or 40 years or so. They take the same language, and different arbitrators interpret that language differently in different cases, even though the fact patterns are very similar. There is no appellate body mechanism to reconcile these different interpretations. And I think that's unfortunate. And also, maybe sometimes the awards are too generous to firms, or maybe they're not generous enough. And again, there's no appellate body mechanism to correct that. So I think that's a second criticism, which is, is fair, and there should be an appellate body mechanism. A third criticism which is made, which I think, I would say has a very small amount of merit, is that the arbitrators who are selected are typically lawyers who have dealt in this area of law for decades, and they know what they're talking about. But they also work for corporations. They work for governments, they work for corporations, whatever. And critics of the ISDS system say you shouldn't have arbitrators who are working on the other side of the fence part of the time. Now, the arbitrators are chosen, one by the company which has a complaint, the other by the government, and then the third, the chairman, is chosen by the two. That's the process right now. So, there is, maybe people who have had a recent case that has any similarity to the facts of the case under issue should be thrown out, even if the other party doesn't throw them out. That's a possibility. Let me wrap up with a final criticism, which has been made very loudly by opponents here in the United States. And that is that regulations made by the state of California, by the U.S. government, maybe by the city of Chicago, to protect health, safety, the environment, if they affect some firm adversely, will lead to a big money award. The problem with that complaint is that all U.S. ISDS chapters have what I would call a savings provision, which says that fair and even-handed regulation, is the natural function of government. And that's not an occasion for bringing a suit. As I said, there are 2,000 or more such provisions in treaties around the world, and some of them don't have that savings provision. So in some cases, an arbitration award has been made against a public health regulation where there was not a savings provision, and the public health regulation or the environmental regulation reduced the value of a property. So that's a problem. That's a problem of those old agreements. That should not be a problem with the Trans-Pacific Partnership.